Yes. Welcome from the Federalist Society. Thank you for coming today. We're really excited for the talk. Two quick announcements. First, this is a zero-waste lunch. All of your paper products can be composted. There's a green bin to my right out here. I would appreciate it if you pitch it there. Also, we're excited for a big lunch talk on Monday. We have 4 appellate judges coming. Judge Smith and 3 of his former clerks, 2 of which are former alum, Judge Ho and Judge Ide, as well as Judge Nalbandian. So that will be in the auditorium, so you won't see it coming out. So make sure you remember Monday in the auditorium. So today, for our Supreme Court preview, we have Mr. Ashley Keller and Professor Baude. Mr. Keller is now a partner with Keller Linkner here in Chicago. Before practicing, he was a clerk for Judge Posner on the U.S. Court of Appeals and for Justice Kennedy in the United States Supreme Court. He graduated from here, top of his class. Professor Baude, his research is mostly in constitutional law and federal courts. He clerked for then Judge McConnell on the U.S. Court of Appeals and with Chief Justice Roberts on the United States Supreme Court. He graduated from Yale Law School. So let's welcome our speakers.
Thank you. It's great to be back at the law school, and we drew straws, and Will is making me speak first. So maybe before we go into some of the cases that are up at the court this term that we think are interesting, and then we're happy to take questions from you about any others that we may have overlooked, it makes sense to address the 800-pound gorilla in the room, which is, how is the court going to look now that it has a new member? And we've all heard the saying that anytime you change a single member of the court, you get an entirely new court, and I think that is certainly true in this instance. Put to one side your views on the confirmation process and everything that went into that and how it has impacted the comity norms that would normally obtain in the United States Senate. I think that it's pretty safe to say that this is going to be a very different court, and from a traditional understanding of conservative versus liberal on a jurisprudential level, this is going to be a more conservative court. If you look at the 12 years of jurisprudence that now Justice Kavanaugh had on the D.C. Circuit, I think you see someone who is markedly to the right of the person he replaced, his former boss, and my former boss, Justice Kennedy. He was certainly careful in places. You could say that he may have been gunning for this position for a while, so he didn't always take some of the more extreme positions that were available to him if he wanted to go full bore on conservative principles. But I harbor little doubt that he's going to be a more conservative justice than Justice Kennedy. And my view is that he's probably going to be a more conservative justice than Will's former boss, the current Chief Justice, which makes Chief Justice Roberts kind of the swing vote, if you want to use that parlance. And that's just a very different court. If you look back at the close 5-4 decisions where Justice Kennedy was the swing vote, which was a position that he occupied very frequently over the last decade, there are just lots of cases that would come out the other way, big and small. And I think that Justice Kavanaugh is going to be a reliable vote for the more conservative side of the ledger when those sorts of issues come up in the future. And so it's going to be on the Chief Justice to decide how narrow, how incrementalist the court wants to be. You know, he's clearly a justice, the Chief Justice, who cares about the institutional integrity of the court and how the court is perceived in the court of public opinion. And so that may be a staying influence. But just in the main, you're going to see a shift rightward on the court, and how far right, is yet to be determined. Turning back to the issue that I started with, which is the contentious confirmation process, which I'm not going to have any prepared remarks on, but if you have questions in the Q&A, we can get into it. There is an interesting issue that's been floated in some of the editorial pages as to whether this is going to radicalize Justice Kavanaugh and make him think that his enemies are out to get him, and so any sort of veneer of seeming to give credence to liberal arguments is going to drop away, and he's going to be a ferocious conservative on the court, as opposed to the counter position, which is having squeaked through on the vote of Susan Collins and having all of the negative publicity associated with this episode hanging over him, if he's going to want to try and restore his reputation in polite liberal society somewhat by moderating his votes. And so I have no real opinion on how he's going to respond to that. I don't know him all that well. It's conjecture for everybody. But my guess is that regardless of which one of those things predominates, you're going to see someone who definitely views the law, approaches the law in a way that's pretty different from Justice Kennedy and more conservative than Justice Kennedy.
So I don't necessarily disagree with all that, but I have some other thoughts. Right. So I do think there are sort of competing theories of how does a justice sort of react to popular opinion? Does it radicalize you? Do you become the new Justice Alito? Does it cause you to crave approval? So do you sort of start doing things to try to win approval? Or do you just sort of put it all behind you and as much as you can and kind of ignore it? I don't know either, and it's like a deep psychological question. I do think it is hard to underestimate, or to say, the justices are remarkably isolated. Like, it's actually like, I mean, some of them read the paper, but they can do a remarkably good job of like being aloof from a huge amount of the ferment that's going on out there. Like, they can't talk to anybody else about their work other than each other and their clerks, who are kind of kids.
Unless you're Justice Ginsburg.
Fair. Fair. Yeah. The year that Ashley and I were clerking, Justice Ginsburg gave a press interview in which she disclosed the outcome of a pending case and explained that she was losing. And the thing that most drove me crazy about this is that she was wrong. She actually like disclosed the outcome of the pending case, and it was not actually correct. And I couldn't figure out if she like didn't remember that she'd actually won already, or was like somehow trolling everybody, or what was going on. But all right, that aside. So I do think like you just put it all behind you is actually a more plausible thing than it might seem from out here, because you can enter in, and the justices have their own kind of collegiality. A couple other things ways to think about how a new justice matters is not just how conservative or liberal is the justice, but what issues do they care about. So the Judge Kavanaugh, who sat on the D.C. Circuit, for example, seemed to care a lot about especially statutory interpretation and the separation of powers. So there's an issue about administrative law, about Chevron, about the president's control over agencies, about whether the CFPB is constitutional since it's a so-called independent agency, but then only has a single person in charge of it. There's a whole range of issues where he was sort of out front and center, writing dissents from the denial of rehearing en banc, trying to get the court to take cases. And that, I think, you can expect somebody who comes in, definitely thinking that there's a vision of the Constitution that they want to help push the law towards. Harder to tell whether he cares as much about some of the other things other people care about, like social issues or criminal procedure or some other things on the docket. I mean, that doesn't, just because you don't care about them doesn't mean you don't take them seriously, but you might not be as aggressive in looking for cases or as aggressive in trying to sort of question or change precedent. I think that's just one other set of questions. Another thought, whenever you have a new swing justice, and I think Ashley's right that will now be the chief, it also changes a lot of the behavior of the litigants and the advocates, both in the tone they write their briefs, the kinds of like appeals they make, what kind of amici they want. So we've had a very long period where Justice O'Connor and Justice Kennedy, who had a somewhat similar form of pragmatism, although in different flavors, have been at the center of the court, and so a huge part of briefing a case has been coming up with the people who would make the kind of emotional appeals that people thought would sway Justice Kennedy and Justice O'Connor. And I suspect people are going to find that those moves don't work nearly as well as they used to, and they're going to need to learn something different. I suspect we're going to see a lot more citations to the opinions of Judge Friendly on the Second Circuit, which everybody thinks the chief loves to see. So I expect he'll be mined for every legal proposition he's ever expressed. Maybe other versions of that, fewer citations to law review articles about the influence of Immanuel Kant on 18th century Bulgarian evidence law and other things the Chief Justice has mocked. There is, by the way, an article on that topic that proves pretty definitively that there was no influence of Immanuel Kant for two reasons, actually, which are
we don't read the same stuff.
So one, Kant had not been translated into Bulgarian by the 18th century, so it's very unlikely there was much influence. And second, Bulgaria did not have evidence law. All right.
Persuasive.
It's like 4 pages long. It's good. The chief would like it. So I think we're going to see just a change in those kinds of tones and arguments. So it's going to take a couple of years for things to catch up.
You want to jump into cases?
Yeah.
Pick your favorite.
All right. My favorite case is Timms versus Indiana, which asks whether or not the excessive fines clause of the Constitution, which is found in the 8th Amendment to the Constitution, if you don't have it on you, is incorporated against the states. Part of the reason that's my favorite is this is mostly a throwback So the court had a huge battle between Felix Frankfurter and Hugo Black about whether to incorporate the Bill of Rights against the states in the middle of the 20th century. At the time, people thought Felix Frankfurter was winning, and then slowly, in some sort of rearguard action, Hugo Black's arguments came around and incorporated against the states almost every right in the Bill of Rights, except for the 7th Amendment right to a civil jury, the 5th Amendment right to a grand jury, the Third Amendment. The Third Amendment against quartering troops, which is tough because states can't have troops most of the time, but I guess the National Guard. Anyway, thank you. And maybe the excessive fines clause. It's the case that arises out of a civil forfeiture in Indiana where somebody was buying drugs using his, I think it's like a Land Rover or something, and they tried to seize it because it's worth a lot of money. And the question is, do we even ask whether it's an excessive fine or not? The last time the court had a case about the incorporation of the Bill of Rights, like the only one it's had in my lifetime, was about the Second Amendment, the right to keep and bear arms, 5-10 years ago. That one was controversial. It was 5-4, with only 5 justices saying it was incorporated. But the 4 who dissented weren't really people who had any doubts about the idea of incorporating the Bill of Rights against the states. They just really didn't like the Second Amendment and didn't think it was a very good right, and so they were trying to sort of control the damage. So my guess is this will be a unanimous opinion saying yes, it's incorporated. But there are some hard questions like why. Under current doctrine, this is all incorporated into the Due Process Clause. That makes it a form of substantive due process, which among some of the justices on the court is sort of a dirty word, and not something a doctrine they otherwise believe in. Justice Thomas wrote a noble concurring opinion saying, actually, we've gotten this all wrong, and all incorporation should be done under the Privileges and Immunities Clause. No other justice seemed interested in talking about that, perhaps for fear of what would happen if we started actually thinking about the Privileges and Immunities Clause. And I suspect that's going to happen again. He'll be the one person to say maybe we should do it this way, but I don't know. Maybe Justice Gorsuch will agree.
Gorsuch.
Okay, yeah, what else?
I think all of that's right. It's an interesting case. There's still a sharp divide in conservative intellectual circles as to whether the Bill of Rights should be incorporated under any clause of the 14th Amendment against the states. Bork was famous for saying that it shouldn't be. Obviously, Will has choreographed the history where Frankfurter and Black were going at odds with each other, and Frankfurter would win every battle but lose the war. Right? The court would never make the blanket statement that the Bill of Rights is incorporated in toto against the states, but every time an issue would come up where the question was presented, they would find in that particular case that the provision of the Bill of Rights in question was incorporated against the states. And so Black didn't get his way in terms of the language of the opinion, but he always got the judgment that he was seeking. And for a guy who wrote the judgment power, that's all that really matters, right? The judgment is what counts, and the words that they choose to justify the judgment is really not all that relevant. I could see a world where a Justice Gorsuch or maybe a Justice Kavanaugh would say that maybe the Bill of Rights shouldn't be incorporated at all, or at least in this case, we're not going to apply it under the Due Process Clause. I haven't checked out the briefing yet on this one. Is it already slated for argument?
Yeah.
Did anybody make sort of the privileges and immunities argument so that they could talk to Thomas?
They give it a couple pages.
So they've preserved it, and
Yeah.
they've given the avenue for the 1 or 2 votes who may require that as the grounds. There's an interesting Mark's Rule question, I think, that could come up depending on how the vote goes, as to whether the privileges and immunities ground is narrower or broader than the due process ground. To the extent that if it's unanimous, it doesn't matter. But if it's fractured, you could see something like that arising. But yeah, I think just an incorporation fight is fun. I suspect that the outcome is going to be some justices say privileges and immunities, either Justice Thomas alone or maybe he has company. The rest say due process. They do say incorporation, but Frankfurter will be able to rise from the grave again in a future case when the Third Amendment comes up in front of the court, because they will not say that the Seventh Amendment and everything else are incorporated against the states. It will be narrow and applied just to the provision in front of them. So similar to what the court has done in the past.
Fair enough. You got one you want to talk about?
Yeah, so a case that I think is really interesting, maybe not sexy and headline grabbing, but of pretty significant import from a business perspective. And now that I sue people for a living, I care about stuff like that. Willie Fletcher opinion in Pepper is up in front of the court, and it is essentially an Illinois brick issue applied to the smartphone era. So for those who don't know, the Clayton Act says that any person injured by anti-competitive conduct can sue and get treble damages, but as proof that textualism sometimes only applies when conservatives want to use it for their policy preferences and not other times, any person has been limited to people who are directly injured by antitrust conduct, which is to say direct purchasers. And that's true even if direct purchasers pass the cost of the anti-competitive conduct on to their end customers. So imagine a monopolist who sells to someone upstream a good or service at an inflated price, and that person then sells the good or service downstream to customers with the markup already passed on, so that their profitability isn't impacted, which is what standard economic theory says happens. The Supreme Court has said it doesn't matter. The end purchasers, the consumers of the product, are not allowed to sue under this case called Illinois Brick, and the direct purchaser, the upstream purchaser, is allowed to sue for the entire amount of damages caused by the monopolistic behavior, which seems a little crazy because you're providing compensation to someone who already passed the cost on and so didn't take a profit hit, and the parties that actually were injured by the anti-competitive conduct in their pocketbooks don't get to sue at all. What the Supreme Court basically said to justify that is, first, the antitrust laws exist to protect competition in free markets, not particular competitors. And so it doesn't matter if the end consumers are actually hurt in this particular case from a societal perspective. It's still fine to have the direct purchasers go after the monopolistic behavior. And second, boy, wouldn't it be complicated if we had to look at elasticities and do math as lawyers to figure out how much of the cost was passed on to the end consumers. We don't want to go through that evidentiary burden, even though complex cases arise all the time where tough evidentiary issues are presented. We just can't do that here in the antitrust context. So this is a simpler, bright line rule, and it's applied offensively and defensively. The question presented in Pepper is, one, what are the contours of that rule? And two, in sort of the software and technological age, are there problems of identifying who counts as a direct purchaser? So the issue there is you go on, if you have an iPhone, you go to Apple to buy all of your apps. And so who's the direct purchaser there? Is it the consumer who's buying the apps from Apple, or is it Apple who's basically entering into contracts with the app providers, with the software providers? And Fletcher, of course, said that the consumers are the direct purchasers. That's the right application of Illinois Brick, and the court took the case, so they're obviously interested in it. And whatever they say about Illinois Brick could have ramifications for lots of cases going forward, because as you can imagine, smartphones and high tech is where the action is today. It's a huge part of the economy. You've got 3 companies over $1 trillion who are basically software providers. So it's a pretty important case from the business interest perspective.
So is there any chance that any of the so-called textualists in the court will say the statute says any person, what are we doing with this whole doctrine?
There would be such a chance if people had the courage to brief it and actually present it, but my fear is that everybody's so constrained by precedent and not wanting to go for the broad victory when a narrow one is available, that it's not going to get the attention that it deserves. But I do think that if you went to a Thomas and maybe probably not Alito, but maybe a Gorsuch, and said, hey, any person means any person, what's this concocted judicial doctrine that prevents any person from recovering, you would have a chance of getting them flipped around.
Well,
hope springs eternal.
we will see. All right, so speaking of surprise, speaking of principal justices, maybe my other favorite case pending is Gundy versus United States, which could be the second good year the non-delegation doctrine has ever had in the Supreme Court.
Schechter Poultry lives on.
Yeah, so in 1 year, in the 1930s, the Supreme Court found 2 statutes to violate the non-delegation doctrine. That is, not to have a so-called intelligible principle that differentiates executive enforcement of the statute from lawmaking. And since then, it's never done it again. And Justice Scalia famously had both majority opinions and dissents where he basically said, this is pointless. There's actually no way judges can tell when a statute is an improper delegation. This idea of an intelligible principle is itself unintelligible and unenforceable, so let's just give up. But hope springs eternal. So the Sex Offender Registration Notification Act, which the court has dealt with several times, imposes a huge number of, basically new criminal obligations on people with past sex offense conviction. They have to register and notify the authorities when they get a new address and so on. But one thing it...
What's the Article 1, Section 8 power that justifies that?
Commerce?
Yeah. Let's fight this on non-delegation grounds. That's the better avenue.
So in Comstock, some related provisions were upheld by the court. So you move to the next battle line. So one question is whether this act applies to people who had their convictions before the act was passed, and the act itself says not necessarily. It applies to people going forward, and then it says the Attorney General shall decide whether or not to require retroactive regulation. So it's like a group of hundreds of thousands of people, I think, whose convictions, who may or may not be affected, and the Attorney General just gets to write regs and say yes or no. And the argument is there is no intelligible principle that governs the Attorney General's decision. Indeed, it seems like the ultimate just kind of punt. There was a House bill that applied it retroactively. There was a Senate bill that didn't, and so we'll just give it to the Attorney General, let him decide whether he likes the Senate or the House better. That seems a lot like making him into a lawmaker. And so there's a non-delegation challenge. A reason to think that the court might actually be interested is no lower court had ever actually liked this non-delegation challenge, but the court granted cert anyway, which the only reason to do that is if you have at least some serious interest in reversing. And Justice Gorsuch, as a 10th Circuit judge, had written a long and impassioned opinion about why this statute violated the non-delegation doctrine, arguing both that it didn't have an intelligible principle and that we should have a higher standard for criminal law. So he's trying not to scare off people who might be afraid of resurrecting the non-delegation doctrine and threatening the administrative state by promising you can have the non-delegation doctrine but only use it for sex offenders and other sympathetic people. Now,
Good.
Now, whether this will actually succeed remains to be seen. The government's argument is, as far as I can tell, we agree that you need an intelligible principle, and even though there isn't one, like, in the statute, you can kind of sense one from the purpose of the statute.
It's an implied covenant of good faith and fair dealing.
The purpose of the statute is to expand registration to as many sex offenders as possible, unless that would be impractical or a bad idea. So the Attorney General is supposed to do it unless he thinks he can't. And that's about as intelligible as the principle that governs your average administrative agency, which is told to do things in the public interest or make rates fair and reasonable or as much as necessary. So I think the battle will be, I think everybody will agree you need a little bit of something, and the question is whether or not the court can kind of make up the something to save the statute from a non-delegation challenge, or whether we will finally find another victim.
Just a few incremental comments on that. First, I totally agree that this has Justice Gorsuch's fingerprints all over it. I'm sure that had something to do with the grant. Second, it's known that he's hostile to Chevron, but this is kind of a step beyond that, right? So the principal critique that I've heard most conservatives make of Chevron is that it's completely atextual. There's nothing in the Administrative Procedure Act that talks about deferring to the agency. But here, there's no textual problem at all with the delegation, right? Like, the statute is crystal clear that the Attorney General is supposed to make this decision. So that would put you well outside of the Chevron context and basically say that Congress isn't allowed, even if it's express, to say that they want some administrative agency or decision maker to ultimately decide the question, and that would have pretty far-reaching ramifications. There is the notion that criminal law is somehow different, but maybe as a good transition to the case that I'll next talk about, why, I guess, is the constitutional question. Like, I guess we have some instinct that when you're going to take away someone's life or liberty, that's a more significant thing than taking away money or economic rights. But it's not clear to me as a constitutional matter why Congress could do something in delegation terms in the civil context and yet would be proscribed from doing it in the criminal context. It raises another interesting question, which is, why don't we give Chevron deference when the Department of Justice interprets criminal statutes, which is maybe the thread that a Justice Gorsuch would pick up on, but there's no clear answer to that question either. And so this is all a constitutional mess. Speaking of the rules being different in certain contexts, another case that I like is Madison versus Alabama. The Supreme Court has a line of precedent saying that the death penalty has to be treated differently in a whole host of ways from every other form of criminal punishment, including that if someone commits a capital offense and is duly committed of that capital offense and is sentenced to death, they have to be competent at the time of their execution in order to be executed. And so the issue here is you have someone who's been on death row a long time. He's been on death row a long time in large part because he has availed himself of the labyrinth of procedural rules that the Supreme Court has made available to him in order to delay his death sentence. You know, he had his raft of appeals and state post-conviction relief and federal habeas, and he's argued everything under the sun. None of it's worked. But now he's so old and had problems to begin with that he no longer remembers, or the allegation is he no longer remembers the capital crime that he committed. And so the question then becomes, are you still allowed to stick a needle in him? Precedent would say that the answer is no. But of course the right constitutional answer is yes. And so they took the case ostensibly to perhaps say so. I can't otherwise understand why this was a grant.
So I think they took the case when they thought Justice Kennedy would decide the case.
Oops.
And he has previously been, in many ways, pushing the boundary on the no side and saying it's very important that at the moment that the condemned person is sort of facing their final judgment, that they can kind of come to terms with what they've done and have a final reckoning and so on. So I could imagine his vote having been to say, no, you can no longer execute this person. But that is no longer what the court looks like. So I suspect it's going to be a tough argument for the challengers.
And Breyer is certainly going to write something about how this whole enterprise is awful because we leave people on death row too long, and so if you have to wait forever to get executed, we should just get rid of the death penalty. That's his shtick for the last 5 years.
Do you agree with Justice Breyer, though, that we leave people on death row for way too long?
Of course, it's not constitutionally problematic, but yes, we leave people on death row for way too long because of people like Justice Breyer who create all of these impediments to executing people.
What would your death penalty appeal system look like?
Like appeals of any other criminal judgment.
So you get habeas. So I mean, is it?
Would I be in charge?
Yeah.
There'd be no such thing as habeas. We'd say res judicata. And you'd have your direct appeals.
Okay.
And after those were exhausted, your sentence would be carried out, and if your sentence was death, we'd kill you.
Okay. That'd be fast.
I'm not even in favor of the death penalty as a policy matter, but as a constitutional matter, that's the way it should go.
Okay, so I have a more exciting case to talk about. It's about interstate sovereign immunity. I define it as the most exciting case of the term, which is the one case in which I filed an amicus brief.
It's all about you, Will.
I will say it is the most self-indulgent amicus brief I've ever filed, because, well, normally an amicus brief is styled as like a friend of the court. We're here to be helpful. I think in many ways this is the most unhelpful brief that I could imagine writing. So the question, just for background, the question of sovereign immunity is whether a state can be forced into court without its consent. And in a series of cases, the Supreme Court has said states cannot be forced into federal court without their consent because federal courts don't have jurisdiction over them. It has said that states can't be forced into their own courts without their consent because the federal government lacks the enumerated power to put them there. There's no Article I power to hold a state accountable in its own courts. But what about when one state wants to get sued in another state's court? So in an old case called Nevada versus Hall, the Supreme Court had said, here is an exception to sovereign immunity. One state can be sued in another state's court. And there's nothing in the Constitution that says that you can't do that, because states have general plenary power. They have no limit on their judicial power. They have no limit on their enumerated powers. So if the state of Nevada wants to haul California into Nevada court, the Constitution seems to say nothing about it. This still strikes a lot of people as very strange.
Didn't the court take original jurisdiction over that?
Yes. So it strikes a lot of people as very strange because, states mostly can't be hauled into the neutral forum of federal court or into a favored forum of their own courts. They can be hauled into the least neutral forum of all. In this case, it's a 30-year, 20-year long-standing litigation dispute between Gilbert Hyatt, who's an eccentric rich inventor, and the California Franchise Tax Board, which was convinced for a long time that he was secretly a California resident, even though he insisted he lived in Nevada. And they sent inspectors over to his Nevada home to peek in the windows and see if he was really there, and lied about it to a bunch of people. And so he eventually sued them in Nevada court and got some tort judgment.
Trespass.
I think it was intentional infliction of emotional distress or something.
Even better. Taxes stress me out too.
So in an amicus brief filed with my friend Professor Steve Sachs, we say the following. We say, the first question in this case is whether Nevada versus Hall should be overruled. Can states be sued in each other's courts? And the answer is, yes, they can, and that part of Hall should not be overruled. Nothing in the Constitution tells states who they can and can't sue, so if they want to do it, it's up to them. But a bunch of the court's other precedents in areas of personal jurisdiction and the enforcement of judgments are confused, and in a way that makes a difference. So everybody has currently assumed that Nevada can get jurisdiction over California in the first place, and that if California doesn't show up, if it tries to default, Nevada could take its judgment and enforce it against California in state courts or federal courts under the full faith and credit clause. All that's probably wrong. There are serious questions about whether Nevada can actually get its hands on California if California doesn't voluntarily appear. And even if California defaulted, Nevada shouldn't be able to enforce the judgment because the judgment would be entered in violation of longstanding principles of international law and common law, and therefore sort of contrary to normal principles of judgment recognition. So we say, like, this part of the law is right, there's other parts of the law you have to clean up. Then in the third part of our brief, the most unhelpful part, we say, this case is a terrible vehicle to resolve any of this.
Take it.
Because, among other things, California has voluntarily appeared in Nevada court, thereby creating a bunch of waiver issues about this jurisdictional stuff. California has failed to do the things it could do to protect itself, like try to seek a declaratory judgment in the Supreme Court's original jurisdiction, or some other neutral forum that would apply the international law principles of sovereign immunity. And even better, the Supreme Court actually lacks jurisdiction over the case under the text of the 11th Amendment. So the 11th Amendment, which is largely a red herring in sovereign immunity cases, says that no state can be sued that the judicial power of the United States does not extend to a suit against a state brought by a citizen of another state. California is a state, Gilbert Hyatt is a citizen of another state, and the U.S. Supreme Court exercises the judicial power of the United States. So the U.S. Supreme Court shouldn't be able to hear this case. I think that's sort of a textbook jurisdictional problem. Now, to be fair, there's a Supreme Court precedent dating back from the 1880s that says that this is wrong, in which the court says, first of all, the 11th Amendment can be waived, even though it doesn't say that. And then later it says that the 11th Amendment doesn't apply to the Supreme Court, because the idea, it's so contrary to the constitutional plan to think that there would be cases that the Supreme Court couldn't exercise appellate jurisdiction over, that we must not have really meant that. But both those precedents are probably wrong. And because they deal with jurisdiction, the court is obligated to consider them sua sponte. So you can't just ignore the problem by saying, well, this is resolved by precedent and nobody's questioned those precedents. You have to at least ask yourself whether those precedents should be overruled. And my hope is that once some of the justices start to look into that, they will realize either the answer is yes, or holy crap, this case is not worth our time, and it was much more complicated than we thought, and dismiss it as improvidently granted.
Anything short of a dig, I predict a cluster of digs. It will not be the well-reasoned, lucid arguments from your amicus filing. It will be a disaster, because this is a place where it's all just what feels icky to me, and what do I not really like, and federal common law, and all sorts of things that allow them to be unmoored from actual constitutional text and principle, and that's when things really go off the rails. So I'm praying for a dig here. I agree with Will that certainly there's nothing in the Constitution that would allow federal preemption of Nevada courts' own rules about whether they want to hear a case against the state of California. A question for you about what you think the enforceability of the judgment would be. I assume you think that there's no international common law principles that prevent a Nevada court from enforcing the judgment, and so if California leaves some of its tax funds in a Nevada bank,
yes,
Nevada could go send the sheriff, freeze the assets, and give the money to the plaintiff.
Yes, and if some California officials decide to take a holiday weekend in Vegas with some state property, Nevada can try to grab it and keep it. That could be fine. But absent those kinds of things, I don't think they can go marching over into the northern
that's
of
not full
California.
faith and credit. I think that's probably right. It's a cool case.
I was going to say something else about it. I just should say the court had this case before, a couple years ago, like this very case, Franchise Tax Board versus Hyatt, with this very question, which is when I first got exercised about this issue. And then Justice Scalia passed away while they were trying to decide it, and they split 4-4 on this question. And so they instead made up a bizarre new rule about the full faith and credit clause that they thought would get them out of the case temporarily. But it didn't, and now it's back.
They should totally take it. That is the better part of valor. I guess another case that I'll bring up, and this was on Will's list too, is Frank versus Gauss. Again, now that I sue people for a living, I care a lot about class actions. And in class actions, the court ultimately determines whether the settlement is fair for the class and what the attorney's fees ought to be. And previously, there was this long-standing practice where, I'll just use the word unscrupulous. Unscrupulous plaintiffs' lawyers would file cases of questionable merit as class actions. They would then reach a settlement with the defendants that involved certifying the class so that there's res judicata consequences for everybody who was within the definition, and sought to pay them their attorney's fees, so they would get money in their pockets. And the defendant would pay some amount of money to a charity as agreed upon between the lawyers and the defendants, as well as some nominal relief for the class. We'll change the comma in our contract of adhesion to no longer do the bad thing that the plaintiff's lawyers accused us of doing, or something like that. And district courts would kind of routinely approve this stuff because, hey, if it gets it off my docket, good riddance to bad rubbish. There's a gadfly that most plaintiff lawyers don't like, but I like him a lot, named Ted Frank, who said, no, this is all BS. And so he went out finding clients, or when he was a member of the purported class, he would intervene himself and object to these settlements and say, what are we doing here? You can't just give all of this money to charity through the CPRE doctrine, it's called. That doesn't help the class at all. And, he just kept taking this stuff up on appeal and making district courts actually do their work and protect the interests of the class. And the chief actually wrote a decision dissenting from the denial, or a statement concerning denial, a couple of years ago, saying, I'm really concerned about this practice, and I've got my eyes peeled for a case that will squarely present the question so that I can rule on it. And Frank versus Gauss is that case. So it's up now, sort of, the QP is whether or not a CPRE award of class action proceeds that doesn't give relief to the class members is acceptable. Class approval of a settlement and attorney's fee awards is reviewed for abuse of discretion. So there may be some wiggle room in a proper case to allow this sort of charitable gift by the defendants, but I think the court very likely took the case to say this is a no-no, and in the overwhelming mine run of cases, it shouldn't be done. And so courts should be looking with a very skeptical eye when lawyers are coming in looking for fees and otherwise giving no relief to the class that they purport to represent. And as well the court should.
So I always have a naive take on these things, although it's similar. Which is every time there's some sort of class action settlement where the class gets something other than money, but the lawyers get money as their share, I wonder why we do that. So I wonder why we don't just have a firm rule that the plaintiff's lawyer's share will be exactly the same, like it'll be a share of whatever the class gets. The class gets coupons for $100 off of a new broken laptop. The lawyers get a lot of coupons. And if they want, they can negotiate for them to be resellable and put them all on eBay, fine. But whatever it is the class gets, they get. The class gets $1 million donated to a charity beloved by one of the plaintiff's lawyers, that his share is more money to the same beloved charity. I think that would solve actually a lot of these problems.
It would do a lot. The one place where I would say some flexibility should be allowed for lawyers to get cash when the class doesn't get that is in cases seeking equitable relief. So if you're getting really important equitable relief for the class, not some BS change in the comma of some contract of adhesion, but it's actually the point of your case to seek an injunction, and you get it, and that has real value for the class, I do think it's appropriate for a court to also allow monetary compensation for the lawyers, because they're not necessarily going to benefit in the way the class does. But that caveat aside,
I don't like that. That's just right, but I don't like that.
I know. It is abuse of discretion, and I do think district courts should have some discretion, but Ted Frank is right, way more than is wrong. That's kind of my view.
An alum of this law school, right?
He is.
Yeah. Should we let them ask questions?
Yeah.
What do you think about a Roberts-Kagan alliance? Is that likely? What would it look like?
Is that a good enough answer? Or? Not likely, I would say.
I think a Kagan-Kavanaugh alliance is more likely. I think she's going to go out of her way to make him feel like she's a sort of textualist, principled ally at the court. So I predict within 2 years we have some Kagan-Kavanaugh concurrences staking out. I don't even know what the positions will be, but I think that'll be that'll be the more likely band. Next, yeah.
Roberts Court has been most pro-business in the area of arbitration, and there was an interesting case last week about one of the questions was about whether the arbitrator gets to decide about the arbitrability of the arbitration agreement and contract. Can you talk a little bit about that and whether you think this is like a line in the sand that they might not cross, or?
Yes.
So, do you want the original answer, or do you want like what they're going to do predictably?
Both.
Okay. Predictably, they will always be pro-arbitration, except for Justice Thomas, who has the principled answer, which is the Federal Arbitration Act is a Swift versus Tyson era statute as opposed to an Erie Doctrine statute, and so it is entirely procedural. That used to be the view of justices like Rehnquist and O'Connor, but they just went with precedent, and of course Thomas will never go with precedent, so if he thinks that's the right answer, he's just going to stick with it. So it should only apply in federal court, number one. Number two, it does not have any preemptive sweep as a result of it being purely procedural as opposed to substantive. And so it shouldn't undo state laws that say, as long as they're not hostile to arbitration. If it was just universally the case under state law that a contract can't do certain things, that would apply with equal force to an arbitration contract. The court has ignored that principle in lots of cases, and I think we'll continue to ignore it going forward because it generally likes arbitration. With the caveat that I don't know where Gorsuch and Kavanaugh are on this issue. If they just go with doctrinally conservative viewpoints, they'll be where their predecessors were. There's a chance they will take the more principled position that Thomas has staked out and view the FAA within its proper sweep. But my prediction would be that they will not do that.
So we might disagree on this one. So I think this might be a case where the pro-arbitration side finally reached too far. So this is the contract is a contract between a trucker and a company, and the FAA has in the text of the statute has an exemption for contracts of employment dealing with certain kinds of transportation. And so QP1, which I think the trucking company thought they had a good argument on, was the arbitrator should get to decide whether or not the agreement is arbitrable, which often the court says yes. But here at argument, justices like Chief Justice Roberts and Neil Gorsuch were both saying, wait a minute, the FAA itself says it only applies, under certain circumstances. But you want the arbitrator to decide whether or not this is even within the scope of the FAA? That seems like something a judge should do. And it's actually the fastest I've seen an attorney just run away from their lead argument in a long time. He started saying things like, well, of course we have no objection to the court deciding. I mean, as long as we win. But now, there is a second question, which is whether or not this person is an independent contractor or not, or whether or not contract of employment means employee or independent contractor, on which they may well win in the end anyway. I'm not sure. But I think there was at least one argument that they threw out there, just thinking at this point the court will take anything as long as it gets a case out of the civil docket into the arbitration docket. And somebody on the court woke up and was like, what have we been doing all day? Next. Yeah.
What do you think is going to happen with specifically the Gamble case in Alabama and then more generally criminal procedure now that we have Justice Kavanaugh?
So the Gamble
I'm
case.
bad with case names.
So the Gamble case is there a dual sovereignty exception to the double jeopardy doctrine? Which under black letter law, you can be prosecuted for the same offense by the state and the federal government or by two states because it doesn't make sense for one sovereign's screw up in a trial to bind another one. And indeed, you could even imagine a state intentionally messing it up, or you can imagine the federal government intentionally indicting a bunch of people and dropping the charges as a way to protect them against state charges. But a couple of years ago, in another buddy comedy duo, Justice Thomas and Justice Ginsburg wrote a concurring opinion saying they both had grave concerns about the dual sovereignty doctrine and didn't think it was justified by the original meaning of the Constitution. And so they were interested in a case to overturn it. They got a case to overturn it. Here we are.
What happened to no incorporation?
I will say, to my surprise, Blackstone actually deals with this literally. There were actually problems under English law, and there were cases where somebody was accused of murder in South Africa and was acquitted by a Dutch court, and then they got hauled into England, and the courts would say, well, they've already been acquitted by a court of competent jurisdiction. I mean, sure, it's the Netherlands, which we have nothing to do with, but that's good enough for us. It would be improper for us to try you again. And Blackstone has a long section about basically saying exactly this. So that's basically what the petitioner's brief says, is you look at Blackstone, you can see this doctrine is totally wrong.
Does it turn on whether the elements of the offense are exactly the same? Does the state get around it by having different elements? Is it the core nucleus of operative fact?
Yes.
Yes?
Yes. So the double jeopardy protections only apply if it's the same offense. And the court has defined the same offense to mean either the exact same elements or one of them as a whole, the included subset of the other. So as long as the federal government prosecutes you for bank robbery and the state prosecutes you for armed robbery, there's no problem. But on the rare occasions where the offenses happen to be the same, there will be a strange windfall for criminal offense. Others? Eric.
So, with a new court, or with a new justice, you have a new court. I guess I was wondering, are there any areas of law that you think have been avoided by the court for the last maybe period of time that now, with a different justice, might just be reopened, that there might be new areas to explore?
Interesting.
Nothing springs to mind. I agree with Will's earlier point that Gorsuch and Kavanaugh seem pretty zeroed in on administrative law and Chevron, and those are cases that have long been accepted at the court, and I suspect they will continue to be, with perhaps more focus on the issues that those two justices care about. But I don't see a major shift in the sort of grants that you're seeing up at the court.
Yeah, that seems right to me. I guess I do think you're seeing this shift in the court's skepticism about Chevron and administrative law happening fast. So the court had another immigration case argued this week, I think, about the executive authority to detain a huge class of aliens. And it's an interesting statutory interpretation problem, and Justice Gorsuch cited his 5th grade grammar teacher, and they all went into whether adverbs modify nouns and all sorts of stuff like that. What was interesting to me is that one of the government's main arguments was also we deserve Chevron deference, so this is a hard question, we should win. Not a peep about that, I think, from the government or any of the justices at oral argument. And that's been true in several of the past immigration cases. It's black letter law that the BIA gets Chevron deference on questions of immigration law, but so far as I can tell, this has been secretly overruled, and there's a sort of pact among the court never to give Chevron deference on an immigration case again, and they're just never going to tell us. I think Justice Alito even said that, actually, in a dissent recently. I think he recently complained that it seemed like the court was no longer applying Chevron deference to immigration cases, and he wondered if there was a secret ruling he was unaware of. Maybe I dreamt it, but I think that actually happened. Others?
I also wonder, too, if Kagan, being the strategic operator that she probably is, will start joining a few conservative decisions to create 6-3 votes instead of 5-4s, with the hope that she can also persuade the conservatives not to overturn precedent. So if she sees conservative precedents that she may not cotton to, she may still join with them in hopes of getting some reciprocation on pet projects that matter to her side.
I meant to say that earlier, actually. I think that is another big, one of the big unanswered questions for Justice Kavanaugh is sort of, in general, where he is on precedent. So I think Justice Gorsuch has made clear already that he's relatively skeptical about precedents if they're wrong. And if you're skeptical of precedents if they're wrong, then you basically don't believe in precedent, because you don't need precedent when it's right.
It's still useful.
It's fun to read. Yeah. It can teach you
better
something.
Than Kant in Bulgaria or whatever.
But, I think we don't know whether the same thing is true of Justice Kavanaugh. And he has gone further than some recent nominees and actually said precedent is required by Article 3 of the Constitution. It's in the nature of the judicial power. Depending on what he means by that, if he decided to adopt a sort of actually a strong pro-stare decisis stance, I think that would just actually make a big difference across a range of cases.
Sure.
Might be good for the court, although I don't necessarily agree with it.
I really love his reference to nominee precedent. That's what really mattered in that hearing. Here's what Justice Ginsburg said at her confirmation hearing, and that binds me. I can only tell you the same thing that she did. It's precedent. Give me a break.
What do you really think, Ashley?
Well, I just said.
Others?
Since Kavanaugh's hearing was so controversial in a different sense than a lot of other close nominations. How do you think, since you both work for the court, do you think you'll be treated any differently by the other justices?
Will Kavanaugh be treated differently by? I don't think so. Will alluded to this earlier. They're very isolated. It's extremely collegial in the building. And I think he's going to be accepted by all of his colleagues, treated the same way. He's going to get along well with allies and people on the left alike. I just think they know they have to deal with each other, and so it might as well be civil. And so that's how I suspect it's going to be.
I think they'll actually go out of their way to be nice to him and to include him. So I think when he was sworn in at the court over the weekend, Justice Kagan and Justice Sotomayor, I've heard were sort of like hastily like ran to the court to make sure they could be there. So it wasn't only with the chief and Justice Thomas and Justice Kennedy. That would be a bad look. I don't know if they were otherwise working on a Saturday. All the justices turned out to the like re-swearing in ceremony at the White House, which I think is not their normal MO. They often stay away from these kinds of events, but I think a unanimous show of force, like there in the front row, they were all here and all like accepting the legitimacy of this process was probably intentional. There's also a story that recently circulated that when Justice Thomas joined the court, Justice Blackmun's clerks decided to protest by keeping their doors shut. So they used to work with the door open, and they like decided to keep the doors shut so they wouldn't have to say hi to him when he walked by in the hallway. I am willing to bet anything that Justice Kagan's clerks do not do that. And that if they were even tempted to, Justice Kagan will tell them that they're not doing that. So I suspect there might be actually like people going out of their way to be collegial, for better or worse.
With that, I think we're out of time, so join me in thanking our speaker.